Daniel Forouzan, host of the Schmoozin with Forouzan podcast. Very excited for yet another episode. Today we're jumping into class action, mass torts, these big cases with Jeffrey Koncius from Kiesel Law. Jeffrey, how are you, sir?
I'm doing good. Thank you so much for having me.
It's a pleasure. Stephen Archer from Kiesel Law has been my mentor for very many years. You came highly recommended. I have dabbled and done work in the world of mass torts. I've done work in the world of class action. I understand that that's what you do rigorously. So it's exciting for me to be able to ask you some questions.
Well, thanks. And hopefully by the end of this, you will not think less of Steve for telling you that you should talk to me.
I'll let him know. So let's just, I try not to get too much into like the background. Tell us where you were born, because I want to get to the meat. But just, I understand that you had a background which was different than the area of law that you're doing now. If I'm not mistaken, you were doing PI and Med Mal, and now you're doing class action, mass torts, and financial services litigation. Is that correct?
Yeah, it is. I mean, very early in my career, 95 to maybe 2000, I was primarily plaintiff side, 60% Med Mal, 40% PI. And then in 2000, I started doing class actions and I've been doing them ever since.
What made you say, hey, here's PI and Med Mal, now it's 2000, here's class actions, and I'm moving over? What caused that?
I had a friend from law school who was a year ahead of me and he was doing it. And it seemed like really interesting litigation to go up against these giant companies and to see what you could do. So to me, it's really been a very enjoyable experience. You don't get to try many cases, although we do have a certified class that we'll be going to trial on early next year in federal court. But putting aside the trial part of it, the practice is so much different than a typical PI Med Mal practice that it's really enjoyable.
Yeah, I remember my first experiences doing class action, working in the class action world, and I'm reading about a class representative and all the intricacies that come into play with that, and all the intricacies that come into play with getting a case certified. Just a funny story, when I was a younger attorney, I was looking for class actions left and right, and I would keep getting my hopes up because I would find something, and every time I would call a class action attorney to run it by them, constantly getting them shot down. Don't get me wrong, I have had class actions, but I've had more shot down than I've been able to actually produce.
Well, no, but I think you and I had one of those conversations, by the way, because Steve told you to call me. And I tell all the young lawyers around here and anybody that'll listen, you're not going to go bankrupt from the cases that you don't file, right? And especially in the class world. If you file a bad case, besides getting your head handed to you, you're never going to get those hours back. And that's just not the way to go. So good for you for figuring out that perhaps that wasn't the direction to go in.
Well, I was young and wide-eyed, and I got excited over everything. And what's funny is now that I'm a little older and I realize the scrutiny applied to the class rep, I appreciate the scrutiny applied to getting certification. Now younger attorneys are calling me and I'm the bearer of bad news. I feel like class action is where the hopes and dreams of young attorneys go to die. But nonetheless, there are class actions. They might be hard to launch, but they exist. I thought as a specialist, as a guy who's doing class action left to right, maybe you could walk us through class size, class rep, injury, remedy, et cetera, in terms of the nuts and bolts of a class action.
We can certainly, I mean, I think the best thing for any young person who wants to get into this is don't get wide-eyed and excited and rush off and file it. There's a lot that has to be done. When you first get the call, whether it's from a co-counsel or another counsel, a family member, they always think that whatever they have is a great class action. And the beauty of doing it today, as opposed to 2000, is that we have this little thing called the internet. And if somebody calls up and is telling you a story about how this product was horrible or this company did them wrong in a certain way, Google is your friend, or DuckDuckGo, or however you want to search. The new Brave browser has its own search tool. But look, and if you look around on the internet and nobody's complaining about it, that should be a giant red flag. No matter how good it sounds to you, if nobody else is suffering it. I do a lot of automotive class actions. We sued BMW over their Mini Coopers, had a timing chain issue. There were lots of people on boards all over the internet complaining about how their timing chain had gone, who were experiencing the same signs and symptoms that our client had. And that's when you start to think, okay, there's something here. So even before you get into the law, the rep, or whatever else, you first have to sit with the idea and see if it's there. If there's going to be a document that the person signed to start out the relationship, like with the phone company or a health club, the first thing you have to do is look at that document, and you are looking for two things: a class action waiver or an arbitration provision. And 99% of the time, you're going to find it. And that's what's going to happen. So somebody's going to call up, I want to sue Health Club X. Okay. You go to Health Club, you find on the internet Health Club X's agreement, or you ask the potential for that, and then look through it. Just do a word search, put in class, put in ARB, and 99% of the time you're going to find one or both, and then that's the end of it. You call them up and you say, I'm really sorry. They're going to be shocked and confused. You're going to explain to them about how that's the way this works. And if you're really that agitated about it, the consumers need to get together and to get rid of these provisions. So that's number one. That's the first step to go through.
What is your take on the whole world of class action waiver, forced arbitration, things of that nature? I mean, you're a plaintiff's attorney. I can guess what your position is going to be, but I still want to hear it.
Well, what's interesting is what's happening now is that people are filing what are called mass arbitration swarms, and where they're basically forcing the hand of the other side. The other side will say, we'll go to arbitration and don't worry, we'll pay for it. Okay, great. If I file 10,000 of those claims, it's interesting how I think it was one of the giant meal delivery services in the Northern District, they were getting so many claims, they actually went to court and said, hey, we want a class action. And the judge said, no, you had this in your agreement. This is your bed. Now go lay there, right? So no matter what side that you're on, if you had people who are willing to talk openly about it, there is no way that the consumer in an arbitration gets what they could get in a court. And that's the reason why the company wants to drag the person there. So just because there is a forum that theoretically allows for it, you're not in front of a jury. You're probably going to have a limited right to discovery. You're not going to have many of the things that you would have in, we're entitled to this. It's civil litigation and we should be in court. It's just like as a plaintiff's attorney, all the time I'm saying to young associates, why do you think defense attorneys always look to remove our cases to federal court, right? It's not because they think the process is more fair for everybody in federal court. It's because most plaintiffs' lawyers don't practice in federal court. Here in the Central District, if you don't have your jury demand and it's on the check off the box form, that's great. Congratulations. You've now just waived your jury like 2 weeks later because you didn't know you had to file a jury demand. All the rules that are there in the federal rules or in the local rules, all these things along the way, it's procedurally that allows the defense to get the leg up. And on the plaintiff side of it, it's for us to know where those pitfalls are and to do something about it. And arbitration is no different. Obviously not a fan. I can't tell you how many cases I've gotten that are good cases where somebody says, I want to do something about this. And it's maybe a $50 product or something. And you have to say, I'm sorry, there's nothing that we can do.
What is this mass arbitration you were talking about?
Well, I mean, there are, I know you had Abbas Kazarunian on, and he has done it. And it's a way of where the arbitration provision is such, it allows you to then file just serially thousands upon thousands of these claims into arbitration. It is not the same though. It is not equal. It's a false equality that if you can do that, that's just like having a class action in state court. It's not, but it does allow a group of people to come together. And then unfortunately though, you as the plaintiff then have to keep track of 5,000, 10,000, 20,000 clients, right? Which is also something that everybody has to keep in mind.
Yeah, that sounds onerous. That sounds like it would be pretty difficult to keep track of all those clients. And by the way, ladies and gentlemen, if you hear the occasional thump, the people above me decided to do construction today. So I apologize if there's some background noise. But anyways, I think the whole idea of class action is such a unique and interesting thing because, you're always trained with ethics. Hey, you got to have a client sign a retainer before you can represent them. And correct me if I'm wrong, class action somewhat circumvents that, where you sign up one client, the class representative, and that client now represents a whole group of people which you might not even have contact with. What do you think about that?
Well, I think that, you use the word circumvent. I wouldn't agree with that word. I mean, the client who is signing up to be your rep, they have a duty to stay informed, and every one of my reps do that. And the defense, believe me, when they take their deposition, is going to say, how frequently do you talk to your client, right? I remember sitting in a plaintiff deposition early on in a case. I don't remember whose rep it was. I don't remember why we were in the case, but what I do remember is that he showed the complaint to the rep and said, when is the first time you've seen this document? And the rep was looking at it in the deposition saying, I'm not sure I've ever seen this before. And I was thinking, oh no. And in California, we have pleading paper, obviously with numbers down the side. And they're like, no, I would have remembered this with the numbers and all of that. I've never seen this before. So that's not a good example of how you want your class rep to be. So the class rep is there to look out for the interests of the class. And I've had reps push back on certain things, right? When a settlement offer comes across, you have to go to your class rep and say, hey, this is what they're offering. What do you think? Many times, just like in a regular case, they're going to say, what do you think? You're my lawyer. What's your advice? But no, it's not to circumvent, and you have to remember you represent everybody. And that's part of when you sign up somebody to be a class rep, you sit them down and you say, look, you're going to represent everybody. And I always bring up the difference between a basic car accident case that if they wanted to settle the case for $500, they could as the plaintiff. But if the defense in a class case says, would you settle for 500? Your answer has to be, is that $500 for everybody in the class? Is that what you're offering? It's not them alone. And they have to understand that. And they certainly can't go in it thinking, I Googled around, I see that a plaintiff can get, like $100,000 incentive award. I want to do that. Because again, that should be a red flag about your rep. If you can't talk them out of it, number one. Number two is, that's again not what a class action is all about. The plaintiff is supposed to be bringing a claim and hoping to recover the same thing for themselves that they do for everybody in the class.
Yeah, to bring the point back to arbitration, I just find the legal mechanism of class action very interesting, with the class rep and the commonality of the injury and a remedy that applies to the whole class. And bringing the point back to arbitration, it does seem like the whole notion of arbitration or class action waivers really undermine that notion. I'm sure a corporate defense attorney would have a different feeling than two plaintiff attorneys having this conversation.
Yeah, of course.
Yeah, but I've been in mediation in arbitrations. The mediator comes in, the mediator can say, hey, you have a sexual harassment case. Here's the weaknesses with your sexual harassment claims. No, the mediator comes in. First thing he says is, hey guys, you have an arbitration agreement. So let's talk about where the ceiling even begins on something like this. From a standpoint of not mechanics, but from a standpoint of policy, even I would say morals and justice and stuff, do you feel that class action waivers and forced arbitration have a place in contemporary American society?
No. It's a very simple, again, they're not doing this because it's fair for both sides, right? They're doing it because under Concepcion, right, the US Supreme Court decision, that they're now able to do it. It's not because, yes, they're going to say, if you had somebody on right now sitting in my chair, they would say, oh, look, it's a much more streamlined thing. It's a much more direct point A to point B. This will get money in their pocket if they're entitled to it very quickly. But look, if it's one person going up against gigantic company, name your whichever one you want, versus a class of people going up against a gigantic company, there's a difference there, right? I spoke to many people in my class actions against auto manufacturers, and they have the problem and they call up and say, hey, my engine just exploded and I only have 27,000 miles on my car. And they say, oh, it's too bad, you're timed out of your warranty, you got a 4-year warranty. And the person says, yeah, maybe you didn't hear me, but I only have 27,000 miles on my car. Why is my engine failing after 27,000 miles? And the answer is, it's too bad, but it's going to cost $10,000 to put a new engine in your car. They don't take that person seriously. But when you bring a class action and that person is leading the charge, believe me, there's a much different response that you're getting on the other side. And I do not believe that if that person went into arbitration against that auto manufacturer by themselves, they would end up getting the same result.
Yeah, sometimes I wish there was more of a public discourse on this topic. I know there was that Wells Fargo issue where I think they were creating fraudulent accounts for their members. And I think for a while there, arbitration came into the news cycle, forced arbitration. That's about the last time I heard about it outside of you and my circles of lawyers. I do think this whole forced arbitration, class action waiver stuff. Look, I'm not saying lawsuits as they are now are perfect. I'm not saying that every lawsuit filed by the plaintiff's bar is some meticulous, merit-based piece of legal extravagance. I'm not. But simultaneously, taking the individual's ability to, like you said, getting especially large corporations to take them seriously, I do find it to be somewhat of a travesty what's happening with those things. And I agree with you. Everything I read, I have a lot of employment cases. So
Yeah, I'm sure it must be, but to your point, because I think you raise a good point. As with litigation, don't get so blinded by your own point of view that you can't see the other point. I always tell the young lawyers here, I want you to know our case. I want you to be an advocate for our case. However, look at the case from the other side of the V, because if you don't look at how they're going to approach the case, it's just like war. If you listen to Jocko, if you listen to, if the good leader has to anticipate what the other side has to say. And to the point about sometimes there aren't good plaintiff cases filed, I completely agree with you. And I have said I'm on the board of a couple organizations, and I talk to these defense folks at giant defense firms. And I say jokingly, I was reading the federal rules of civil procedure. There's actually a thing in there called an answer. You don't have to file a motion to dismiss as your first pleading. I don't know if you know that, but I just wanted to point it out for you. And for the state court people, I say the same thing, but I say demur, right? And they laugh and they say, that's funny, Jeff. However, you don't understand what comes across our desk, right? You guys are obviously going to file a real case. I appreciate that. However, so many cases get filed that the companies get hit with that even you would agree are nonsense. And so we have to be able to do something about that. So I think you're right. We shouldn't be blinded to the fact that being on the plaintiff side of it, that every case is a great case, because we all know that unfortunately some of the cases that get filed are not great cases, and that creates bad law, which is a real problem for those of us on the plaintiff side.
yeah, absolutely. And then there's there's an issue of, socially, how are people looking at these things? I remember there was a class action against Red Bull, which Red Bull settled, I think, fairly quickly for 10, 11 million. I don't know. It was public. And the clickbait story, this is actually before clickbait, but it was clickbait. The headline was, what's it called? They settled the lawsuit because Red Bull doesn't actually give you wings, or something to that effect. Do you remember this?
I don't, but it reminds me of other ones that I'm not sure I want to name, but yes, I could imagine that somebody did file that, because that sounds like it, right? I drank a can and it didn't give me wings, right?
I took a closer look at it, and I'm not sure that lawsuit ever alleged that the product doesn't give you wings. The lawsuit alleged that Red Bull is putting caffeine and vitamin like B and water together and pretending it does something it doesn't. As part of the complaint, it did have some, fancy language. They went into there, and I wouldn't call it necessarily hyperbolic, but they're trying to be advocates. And they say, this product does nothing special, but here they are advertising it as if it gives you wings. And that got contorted to, because they say it gives you wings, that they filed this class action, which wasn't the case. I saw a lot of people on my social media complaining and saying, why would Red Bull ever settle this? These things are out of control. My experience has been the legal news out there, whether on class action or otherwise, is shaky. From the perspective of, let's just say, tort reform or policy, or the zeitgeist of America, where do you think these things are headed? Do you think people are aware? Do you think people are fed up? Do you think people don't care? Maybe they're going in the other direction.
I think it's all three. I mean, when you asked about arbitration provisions, is this in the news every day? It's not, because nobody's thinking about it until it happens to them, right? And so that's the issue when you have to tell a consumer saying, sorry, I can't bring this. There's a class waiver and an arbitration provision. What's that? And you explain, and they say, how can they do that? And you have to say, well, they've been doing it for a long time. You just don't know about it. How come I haven't heard about it? Well, maybe you should amplify it among the people that you're speaking with. And I think it's going to be there. This whole idea, for example, back when I was doing med mal, and we have MICRA here in California, which caps damages at 250,000. It's a net attorney's fee, which is on a sliding scale downwards. I think first $50,000, you get 40%, next 50,000, a third, next whatever, 25%, and it keeps going down. So, and damages are capped at 250 for pain and suffering, right? So these are not out-of-pocket damages, but this is just pain and suffering. They know that, the defense does, going in, that worst case scenario, it's a 250 case. And they know you're going to have to hire experts at $10,000 per, and they know that your fee is going to come off of a net fee. And there's no motivation to get anything done. Now, what's the story behind that law? It was passed in I think the early 70s, right? And
Sorry, Preston.
that's quite all right. So they passed that with the 250 cap back in the 70s, and in today's dollars, that would be, I think, north of 700. Nobody expected it to be frozen in time at 250. So I think these are all issues that are there that people are just not aware of. And then they trot out MICRA and saying, look at what a great job it did by keeping insurance premiums down. And I think that's been disproven. So I think it's a lack of knowledge, not a lack of care on behalf of the public.
It's weird to me how many doctors I see worried about getting sued, or maybe not. If I looked at it from their perspective, maybe it would be different. But whenever they all, like my brother's in med school, I hear about this from the doctors on social media. When doctors talk to me like, oh my God, a lawyer, what's going to happen? But I always wonder, like, do they know what MICRA is and how that keeps a lot of these lawsuits at bay? In fact, I can't imagine too many individuals, whether professional or otherwise, who have the protections of MICRA. But with MICRA, and I'm glad you brought that up, I hear a lot of stuff. CAOC, this person, that person is going up north to the legislature. They're lobbying. They're saying the 250 cap is not good, et cetera, et cetera. I don't hear anything like that about forced arbitration or class action waivers. Do you?
Well, so there are some organizations that are doing that. You have Public Justice. You have people who are trying to amplify. So this, when the stories come out, for example, Amazon a few months ago very quietly removed the arbitration provision from their terms of service. It used to be, it was very simple. Jeff, there's a potential on the potential class action person. Hello, yeah, I bought this product from Amazon. I want to sue them. Well, unfortunately, there's an arbitration provision. So that's been removed quietly, but they did that, we think, in light of a bunch of arbitrations that were filed, I think in the employment context, if I remember correctly. So it's more of a reactive thing, and we on the plaintiff's side have to do a better job of amplifying the message, right? Because unfortunately, it is still, and I'm sure you know this, if you were to say to somebody at a cocktail party, what do you do? Oh, I do consumer class actions. And their first reaction is, oh, I've gotten that notice in the mail, and then I got a coupon for 50 cents. Yeah, you must be really happy about what you do for a living, right? And then I have to kind of walk through the cases that I file and I work on and get them to understand, oh, okay, I see what you're doing. So I think it's a messaging issue, and it's rare that I talk to people who agree with the status quo and think it's appropriate. I know them, right? They're conservative folks. They're entitled to their opinion. It's not an opinion I share, but the vast majority of people that are in the situation, it's a surprise to them. So I think it's a messaging and it's an amplification issue. And CAOC has been trying really with the cap to get that moving. And it's really nuts how they can't get traction on that.
You know, the funny thing is, even if you had a person who had a conservative viewpoint regarding class action waiver and arbitration, I think making the point that you made earlier, the car company is not going to take anyone all that seriously. Are you a well-to-do conservative guy? You have a $100,000 Mercedes. Okay, if that Mercedes, if it's having that issue, even though you bought an expensive car relative to Mercedes corporate, you know, you're not going to be high on their list of people to be all that worried about. Even the person who has a politically conservative viewpoint on class action or arbitration, I think, can appreciate that these large corporations aren't going to pay attention to individual claims. So when you say, I think it's a messaging issue, I tend to agree with you on that. I sometimes wonder if the other side of the bar has done a better job at messaging. We all know the McDonald's case, hot coffee case. She got burned because her hot coffee was too hot. I'm sure you know that's not the case. I know that's not the case. I've seen what the burns look like. I'm aware of the fact pattern. I'm aware of the $20,000 or so demand that was made. But it almost seems like the defense bar is maybe ahead of us on messaging. But you tell me, what do you think?
Well, first of all, you raised a funny example because I'm a cyclist. One of the guys I ride with is a very conservative guy, and no matter, I don't care what the case is that I tell him about, his answer is buyer beware. That's all he has to say. I've never been able to tell him. I say, hey, I think I finally have a case you'll agree with, and I tell him the fact pattern, and nope, it doesn't matter. So I just think that the problem is the headline is lady spills hot coffee on herself from McDonald's, gets $3 million, right? If you went up and took a poll and you asked people, hey, have you ever heard of that McDonald's coffee case? Assuming they had, I am sure they would say, oh, the one where the lady spilled the coffee on her lap herself and got $3 million. And you would sit there, you're like, this is an alternative universe we're living in. So I think it's a messaging issue. I think that when people see the amounts of money that they just assume that the lawyers are getting all of it, and it's not going through to the consumer. They don't hear about the cases where auto manufacturers are forced to extend warranties, give refunds, put in for free repairs. They don't hear about the people that push products out that don't work, and they don't care because, and their internal emails that say, don't worry, we'll deal with it in the warranty period, right? That's not stapled to the display in the store that says, hey, when you buy this, just so you know, here's an email from Joe in engineering that says, yeah, we know it's not ready for prime time, but we'll deal with it in the warranty period. So it's just very difficult. And that's why I like what you have behind you. You're all about advocacy and doing good work for a small group of people. You don't have a PI mill at your place, and that's what it's about. It's taking the good cases and willing to take them all the way to the end. If you're filing a case and you're not willing to stand up and try it, or you're not willing to explain it to your friends and family, or stand up in front of a jury and try and not be embarrassed about what you're going to say, you shouldn't be filing that case, right? It's very simple. And I'm sure you pass on more cases than you take.
Yeah. Do you think, and thank you for that, I appreciate the compliment. I take it as a compliment. Some people like having volume, I guess. I don't. I prefer of high quality cases where I could white glove them. But do you think the defense bar is winning in the messaging forefront?
I do. And the reason why I see that also in court, and you see that in the filings, and you do see that in the legal news, one of which I won't name, that we all subscribe to because we have to, but it's very defense oriented. And for many years, I would get a call from a reporter saying, would you like to comment on the motion to dismiss being granted, right? And I would say to this person, how come I never hear from your organization when I get a class certified, or there's a good settlement, or when I've beat the motion to dismiss, or I've defeated the motion for summary judgment? That's never being reported. It's only the other side of it. That organization has gotten better, but I think the way you have it play out in the media, I think they have a better handle on it. I think that their filings like to bring up the McDonald's case and whatever else. I think that you have, I just think that the person's natural reaction, like the guy who I ride with, what's your fee going to be, right? That's always really important. What's my fee going to be? As opposed to what did I recover for the class, and how come you get the fee that you're asking for? Well, I just defeated a major auto manufacturer who I litigated against for 4 years. You don't think I deserve to get paid? What do you expect? I'm not delivering newspapers. So, I mean, everybody gets paid an amount. I mean, I used to deliver newspapers. It's hard work. And what I do now is hard work, and I expect to be paid for it.
And I think sometimes the politics gets in the way, and people miss the fact that maybe without fee shifting provisions, maybe without attorney fee provisions, who's going to go up against some major class action that's selling a product that's causing people chemical burns? The chemical burns on their own, like you mentioned earlier, may be worth a couple $1,000s of medical bills each. But when you stack those together, now you give the company impetus to change their ways. But you also have to give the lawyers impetus to bring those cases in the first place. Again,
and that's why under the labor code, they have a fee shifting, right? An attorney's fees provision. Most of what I do, unless you're unless you're doing it right under the CLRA, chances are you're not going to be able to get an award of fees pursuant to statute, right? So it's only going to be out of what you create. But I think those attorney fee shifting provisions are really important, to your point, because for the average person, they're not going to bring a labor code, they're not going to bring an employment case just because. We all have just because cases, and there are some cases we feel very strongly about that we bring no matter what. There are many lawyers who do great pro bono work as well. However, you don't want to do a lot of what I call involuntary pro bono, which is where you're litigating a case and you realize, oh man, I might never get paid on this case. So I think you're right. The ability to incentivize attorneys to take on cases is very important.
Yeah, and when your cycling friend asks you how much did you get paid, well, look, even if you did get paid, a significant sum, without that significant sum is the incentivization there for people to take on large corporations. And I'm not suggesting that every attorney who goes in files a class action, the lawyer runs away with $100,000 in attorney fees, and people are getting 50-cent, coupons on whatever it might be. I'm not suggesting, again, every class action filed is a marvel of litigious ingenuity. I'm not saying,
no, far from it. And I'm not saying that either. I mean, there are some times that I hear about a class action that's been filed, and I just think to myself, it's completely understandable why people bring up to me, how can you do that kind of work when you hear a case? And I'm sure you hear about an employment case or a plaintiff case. I say all the time, if somebody calls up and says, I slipped in the supermarket and I may have hurt my back. Yes, there are people that file those cases. This is not one of those places, right? And that's why I'm happy. We do significant personal injury. We do large class actions. We are involved in large multi-district MDL or JCCPs. We do mass torts, right? These are cases that you're not going to be embarrassed about standing up in court and explaining to the judge what your case is about. You might not win, but you're not going to be sitting there mumbling and saying, God, I really hope they don't ask me any questions about this at the next party because this is embarrassing.
Let me ask you this question. So in terms of class action, we have COVID, we have social media, we're in the digital age. Goodness, even when I started doing class action, none of those things were quite there. Now they are. What's going on with class action and COVID? Are there areas of the law that you think have applicability in this landscape insofar as class action is concerned?
Yeah, I mean, we have not filed any COVID related class actions, but you can definitely see the ones that have been filed. A couple of them come to mind where you have some sort of a contract that's been entered into, typically with like an educational institution. And then when COVID happened, they all shut down and people said, I put all this money down for housing and obviously I'm not going for housing, so give you my money back, right? That's a reasonable thing that I think even my cycling buddy might actually agree with. And of course,
on the podcast.
Yeah, we'll have to see him next, right? Yeah, if he does show up as a guest on the podcast, why don't you ask him if he would have worked for free for 4 years in the hopes of getting paid 4 years from now, and let's see what his response is. But I mean, COVID brings interesting questions, right? When you have an incident that's affecting a lot of people, then the question is on the plaintiff side to be creative, not creative as in thinking up something totally wacky so you can file a ridiculous pleading, but think creative. How can we bring these people together? You're not going to sue a giant educational institution over a $400 deposit, right? But think about it. Everybody else in that dorm had the same issue. How can you bring this in? Is this a breach of contract? Is there something in there about, an act of God? Is this an act of God? I mean, there's plenty of litigation that's gone on already about business interruption insurance, right? And it's the same thing there. What always happens is you have some major event and then attorneys unfortunately have to fill the void because people start fighting. No, I don't have to give you your deposit back, or no, COVID is not covered. And I think the landscape is there. I think there's a very interesting area right now in terms of privacy that's going on. And we're involved in a number of these cases where I have sued Facebook multiple times. And one of those cases lasted longer than 10 years.
Wow.
I think it was at least 2, trips up and down to the Ninth Circuit. So there's a lot of privacy litigation going on. And that's been interesting to see that kind of bubbling up of people finally understanding that if they think something is free, it's not free. You're the product, right? I can't tell you how many times I've stood up in front of a group of people and I said, who thinks Facebook is free? And whatever, a lot of people raise their hand, like, who can explain to me why Mark Zuckerberg is a billionaire, Facebook is free? And nobody can figure out, it's the dot connecting that seems to have gotten lost there. And in my world, there's a lot of interesting litigation now in the privacy landscape and the online snooping that's happening, whether it's the Facebook invisible pixel that's on there, whether it's the tunnels that are creative when somebody is getting on a hospital's website that says, we don't share your information with third parties, right? But they have the Facebook pixel on the sign-in page to their secure portal, right? And when you go to that thing and you sign in, it sends a message to Facebook saying, hey, this person just signed in. Now the hospital would say, well, it doesn't say this person, it's just some random bit of information that gets sent to Facebook. But anybody that has a Facebook account has a Facebook cookie on their machine. And that's what Facebook does for a living. They're going to match up my login with my ID and say, oh, that 54-year-old guy that likes to ride a bike and do jujitsu every once in a while, he just signed into this hospital's website. Now we can send him targeted advertising, right? And then we then have to figure out how to make that into a claim, because that doesn't sound right. If I'm being told by a hospital, we don't give your information to third parties, and yet they're creating a tunnel and telling Facebook and Google right when I sign into the hospital website, Jeff just successfully logged in, that means they're telling them I'm a patient. And what we do is we say to judges, Your Honor, if I was standing here today and I told you that the hospital said, Dear Mr. Zuckerberg, we want you to know that Jeff Koncius is a patient of our hospital, you would be looking at the hospital saying, why are you telling them that? What gives you the right to do that, right? But because it's digital, it was just like the first data breach case until there was no standing for many years, because they would say, what's the harm? So your data's been breached. Okay, but show me that somebody bought the information on the dark web. Show me that your credit was impacted. Otherwise, get out of here. And then eventually the court started figuring out, like, wait, there actually is a claim here. And so that's for us to do as plaintiffs, is to keep pushing and to push the boundaries. And sometimes you lose, and sometimes you then take it up to the Court of Appeal or the California Supreme Court, like we've done, or the Ninth Circuit, US Supreme Court. But if it's something that you believed enough to file in, you should consider, when you get a bad result, maybe it's something that you should also believe in taking up.
Okay, let me, I actually want to talk to you about jujitsu in a second. All right, well, we'll just jump to that. I know that it's an interesting thing, because when you and I first started speaking, I was surprised to find out, oh, it's another lawyer who follows mixed martial arts. I don't know if there's a lot of us. I know mixed martial arts is taking more of a prominence now in the world. In jujitsu, which if anyone watching doesn't know what it is, it's the ground combat element of mixed martial arts. And you actually mentioned this when we were talking earlier. You said it's a bit of a chess game, and I agree with you. First off, how did you get into jujitsu? What brings a lawyer into ground combat exactly?
I like that. I'm happy you didn't say what brings a lawyer of your years or your age or anything like that into jujitsu. So I'm sure you've heard of Jocko Willink if you listen to podcasts. Look, he's a Navy SEAL. I'm hearing about him talking about jujitsu all the time, and I'm thinking, great. If I look like Jocko Willink or Dean Lister, yeah, I'd be doing jujitsu too. But that doesn't apply to me. However, I also listen to podcasts from Sam Harris, the neuroscientist, right? And listening to him, thinking, and he was discussing jujitsu and his experience in the sport. And I was thinking, that's weird. You have kind of like a thinker, a meditator talking about jujitsu. You have a Navy SEAL talking about jujitsu. And then Tim Ferriss was talking about jujitsu. And then, it kept going on and on. So I kept hearing about this. And then finally, I think my wife got sick of it and just gave me for a Christmas present, a gift certificate to go get 4 private lessons with this jujitsu place. And she happened to buy it at the wrong place, which was great because it worked out really well. And what really struck me is, and this, is that what's fascinating is first of all, the body-to-body contact. It is rare as an adult male that you ever have another adult male rolling all over you, grinding on you, parts of the body fluid, all sorts of craziness. That doesn't happen. Then you add into that, you're in your basically pajamas and a gi, right? And then you're also getting your ass kicked by somebody who weighs, I'm 190 plus a little bit. And meanwhile, I'm getting tapped out by somebody who's in like 140 or women who are even lighter. And I just started thinking about it, when I first started practicing it, I was like, God, this is just like a chess game. They do this, you do that. And it's just like litigation, right? They do this, you do that. Or how can I anticipate what they're going to do? So it's really intellectually probably equal to, if not more stimulating than, I mean, physically, it's very demanding, but intellectually, it's really incredible. And I'm wondering if you found it the same way. What did you practice jujitsu as well, or other combat arts?
I think saying I practice it may be an overstatement. I'm very familiar with it. I have practiced it when we were younger. We would go to my parents' bedroom, and when our parents weren't home because they had the largest bedroom, and we'd roll out a rug and start rolling around. Back then, that was normal. Clearly, I wouldn't do that again now. But I will say that I think anything where you're practicing, if they put their hand here, I got to put my elbow here. If they put their knee here, I got to do that. This constant tug, pull, tug of war that you're having as you're doing jujitsu, I think it's very disciplinary. I think it's very, I remember when I was earlier in my litigation, I would get a little annoyed with defense attorneys. Why are they filing this demur? Blah, blah, blah. There's no grounds for this. But the truth is they're just countering what you're doing, and you're countering what they're doing. So I think martial arts, jujitsu in particular, the other thing I like about jujitsu is no one's punching you in the head. So
yeah, that's a benefit. Although, I mean, that's true. I do like the idea of not getting punched in the head, but I do remember leaving class a couple of times where I was so wiped out. It's just an amazing experience, and you're put into very uncomfortable situations. And there's a great book that just came out by Hicks and Gracie called Breathe. And it brings together, I mean, three great things that I love. I mean, stoicism, mindfulness, and also just the physical act of jujitsu. And you get put in a position where, look, at any time you could tap the person and say, I'm out. It's not like you're going to rip your arm off or something. It's not like you're in a cage fight or something, but you don't have to tap right away. Just because you get into an uncomfortable situation doesn't mean that's the end and you have to immediately then tap the person and say, okay, you got me, right? They can have you in an uncomfortable situation. And while you're there, you have to learn to calm yourself and then figure your way out of the uncomfortable situation, right? Nobody likes opposing a motion for summary judgment, but the fact is you have to do it, right? And you have to do the separate statement, and you have to get the declarations, and there's a reason why they give you 75 days in state court, right? It's notice, because it's a massive undertaking to do. And so it's just like anything in life. You're going to be in uncomfortable situations, and you don't get the chance to tap out or go bonkers every time that happens. You have to start thinking clearly about what's the next step? How do I solve this puzzle?
Yeah, pushing past stressors is, I'm sure, a conversation you can have with an athlete or a litigator. In fact, it's an interesting thing when I talk to people about being a litigator. This includes people who work in business, people like doctors. It's a unique thing to be a litigator because there's literally someone else on the other side of you, trained with the same training that you have, trying to screw up whatever it is you're doing. And the doctor friend of me goes to me and says, yeah, but as a doctor, you have to compete with other doctors. And I reminded him, as a lawyer, I have to compete with other lawyers as well. That's no different here. It's just, in addition to my competition, the mechanism of my work is adversarial. And one of them, I apologize, guys, if they're doing some crazy stuff upstairs. I hope it's not making too much noise on the podcast. Okay, my roof is literally shaking here.
Maybe we'll be able to see a tort in action.
I know. Oh God, I hope not. But if I do, hey, I know who's going to represent me. The adversarial nature of sports is one of the few things where I think that's comparable to litigation, because, the guy who's running the ball up the basketball court, the guy opposed to him is also trying to screw him up, steal the ball, slap the ball away when he shoots, get in his face, whatever it might be. It is interesting to me. Sometimes it's the athletes who appreciate the stressors of litigation more than like a business person. Have you ever had an experience like that?
Yeah, of course. But I mean, to your athlete perspective, just keep it going. And I think it's important. What normally happens at the end of a boxing match or a jiu-jitsu match or a basketball game, typically they shake hands and show some sort of respect for their opponent. And that's the part that I really think that we as lawyers, look, this is a profession, right? This is supposed to be. And I can't tell you how, I don't know if this has happened to you, but when I get a referral to me from a former defense attorney, my former adversary who's referring me business, That's the highest compliment that I could have. And the reason is because, yeah, we've all seen those out of control, crazy litigators. We perhaps have even had cases with them over the years, but the goal is not to act like you see on TV or in the movies. I call myself the anti-litigator because my role is not to inflame things on the sides. My role is to zealously advocate for my client. My client wants to go crazy. That's my client's doing, right? And I've had plenty of situations. I represent an old man who was suing his son. His son came to him. There's a guy during the Depression, and he invested his money very well. And his son was in his 60s, and this guy was late 80s, maybe even 90. And his son says to him, Dad, I could save you in taxes if you put all of your investments in my name. And don't worry, I'll give it back to you whenever you want, but just put it in my name. So of course the guy does, trusting his son. And then of course, when he says, give me it back, the son won't. So I end up suing the son and representing the dad. And during the son's deposition, that at the time I was a younger lawyer, and the senior partner at the firm wanted to take the deposition of the son. The son is testifying to certain things that my guy doesn't agree with, and he's muttering. And he was a real scrapper when he was young, my client, and now this 90-year-old man. And he's muttering, that's not true, that's not true. So finally he was disrupting too much. I said, hey, we gotta go out. So I'm walking out of the conference room with him, and as he's just about to leave, he decides to punch his son in the head during the deposition. Oh, right. And as he winds up to really and his son had no idea this was coming because he's testifying and the father's coming from the side. I then pick him up. I'm like, okay, we're done. And I take him out of the conference room. So again, the fights between the clients, and hopefully not a physical fight, don't make it between the attorneys. So many times I see and I hear these caustic emails that are being sent across. I mean, it's such a bad idea on so many levels. I mean, back in the day, and I know this is hard for people to understand, if you annoyed me and I wanted to say something to you, I had three choices. I could meet you in the street and tell you to your face what I thought. I could call you on the phone and tell you, or I could write you a letter. Now, chances are most people are not going to accost the person on the street because they're too worried about getting into a fight. So that's not going to happen. Most people are not going to call them up on the phone. So what you ended up was dictating a letter, which you'd have to get back. And then you saw it in print and you're like, yeah, maybe I shouldn't send this. But nowadays it's so instantaneous, right? And you get these emails from people that are just crazy. And you're thinking, this is great. This could be an exhibit. I'm sure the judge is going to love to see this. And the adversarial nature of what we do, you're right. We're constantly butting heads with the other side, but that doesn't mean that we can't be a professional as we do it. And I think I've only yelled once at somebody in my career, an adversary. And I have many former adversaries who are my friends and refer me business, and I refer them business, more importantly, right? And that's what this is, a profession. So yeah, keep the fighting to the mats and doing jiu-jitsu, and then just focus on what you're doing in the office and the courtroom.
Yeah, it's an interesting point you bring up. These two people are in an octagon, beating the daylight out of each other, and then they go and they shake hands afterwards. I think it shows something about professionalism. I think it shows something about professionals. I don't think the average people who fight in a bar or whatever it might be shake hands afterwards. I think the people who are actually trained to do that are the ones who have a degree of decorum that comes with it. And the second to last podcast that I did was with a Mr. Rex Paris. I'm sure you know who that is. And he said the same thing. He said, look, what is persuasive about a nasty correspondence?
Yeah.
What are you going to get, whether it's from the adverse attorney or from the judge who reads it? And I remember, and sometimes, look, it's worth repeating these things to myself. The beautiful thing about this podcast, it's a consistent educational opportunity for me, speaking with people like you. There's a story from Abraham Lincoln. He said, when I'm angry, I write my thoughts in a letter and I put
it goes to the desk.
Yeah. And then the next day I take it out of the drawer and I reread it. And if I think I should send it, I will. And I've never once sent it once I reread it when I wasn't angry.
Yeah, but how many times, that's great. And that's the way it should be. Have some self-reflection about what you do. If you go to court on a dispositive motion and you lose, I'm the first person over there shaking their hands in front of their client. Well done. Did a great job for your client. Am I mad that I lost? Of course I am. But think about it. They did a great job for their client. Should they have won? Of course not. I filed the case. I thought it was a good case. But once again, be the bigger person. Think about what we're engaged in as professionals and as lawyers. We're not in a barroom fight. And that's what some plaintiffs' attorneys would say, or some defense people would say, no, that you're absolutely wrong. This is a barroom fight. No, it's not. This is a profession. And one side's going to win, one side's going to lose, right? If it gets to either trial or a dispositive motion, and then congratulate the person who just beat you because you thought enough of your case to file it and they got rid of it. Are you angry? Of course you are, but they did a great job for their client. There's no way around it. And if you create a level of hostility, they're never going to settle the case either, right? That's another thing that seems to be lost on people. Everybody's like throwing bombs at each other. Like, how is this productive?
Yeah, especially as a contingency-based plaintiff's attorney. I had the privilege of being mentored by the insurance defense and corporate attorneys, and they always pointed out to me, like, look, of all people in the world, you're the one reaching your hand out and saying, please give me money. More than anyone, you should be polite. And I remember as a Rosh Hamanpur, actually, at a Kala event that I went to, he made the same point and, kind of echoed what you're getting at here, which is, since we're the ones asking for money, we're not paid by our clients. We're actually paid by the people we sue, which is kind of
which is somewhat unique, right?
Yeah, exactly.
But to your point, it's interesting that you started your career doing that and sitting through hundreds of depositions and defending all the people that you did. Besides being great training, it also gave you kind of a glimpse behind the curtain, and you understand what's happening on the other side and the motivations. And sometimes, just to remind myself, we have a few folks here who started out on what I call the dark side, who wore the black hat. And I go up to them, I say, hey, look, put your black hat on for a second. I want to talk to you because I really do want your input. And you can have those honest conversations, assuming that another good reason to be friends with your adversaries is assuming that you have a long enough career, you're going to see these people over and over. I'm sure you see it in the employment world. There's only so many people that defend the cases that we file. And if you had a horrible experience with them the last time, why do you think it's going to go swimmingly the next time? You can try, but there's a lot of bad blood to get over. And you can have that open conversation with the other side. And you could say, hey, this is a different case. I'm really thinking this. So what can we do about this? So it's just another reason to remember that about the professional side of this.
Yeah, it is. I did work for a while in the entertainment industry. Back when I was going to law school during the day and I was working in entertainment, I went to law school in the evenings and I worked in entertainment during the day, more transactional, more creative process and the legalities that are involved in it. I was just experimenting with that area of law at the time. Now I'm obviously a full-time litigator. But what I noticed about the entertainment industry was it was one thing talking to the business affairs people and the lawyers, and a whole nother thing talking to, maybe, I don't want to point any fingers, but other people involved in the production of a film, whether it's, talent, whether it's producers, the lawyers, the blood-sucking lawyers, as they called us in Jurassic Park, were the more professional, even the adverse, when there was a situation that happened. This might sound strange to people, but sometimes I feel like lawyers are the lubrication that keeps certain aspects of society going. Just to explain what I mean, I was involved in a trial, I think it was 2017. We had a 4 or 5 week trial in Riverside. If we let the clients just like put them in a room, they would have killed each other. It was not going to work. They needed, as much as people hate lawyers, they think, oh, you bog up the system. The business people, had we let them to their own affairs, would have gone just reduced to hand-to-hand combat. They hated each other so much. So
no, that's true. And sometimes, look, we sued all the movie studios in town, every single one of them, class actions about profit participation on home video royalties. Many of the people that we represented had contracts that never talked about home video royalties. Why was that? Because there was no such thing as video when they entered into these contracts. So the question is, what is appropriate under the contract? That's not going to be resolved by the business affairs person and the estate of somebody to get into a room and try to negotiate that out, right? It just doesn't work that way. And so that's where we step in and hopefully help to push the law, to push the idea towards a certain direction, and the defense to push back. And they're saying, no, that's too much. And no, we don't agree. And then to have somebody there like a judge who can, not like a judge who can then regulate what's going on and be the person who's overseeing the entire operation. Because you're right, if you just put the two clients in a room together, obviously if they could have resolved it, they would have done that before they ever went to their lawyers, right?
Yeah,
So
exactly. They wouldn't be lawyers if that was the case.
exactly.
It is, a lot of what we've discussed today here seems to be about messaging. Maybe we need to get a billboard with a photo of you and me saying, "Hey guys, trust us, we're not that bad." I don't
Yeah,
know.
exactly. Exactly.
I'm sure there's people who would disagree. I'm sure there's people who I've sued that would disagree. I know one person in particular holds a animus towards me, even though he was committing day-to-day wage theft against his client, against his employees. But okay, I do think lawyers serve such a critical role in society, and I think that's been a part of our conversation. Speaking about roles in society, a couple of things that I want to touch upon. I want to talk about mass torts, including toxic torts. But you brought up some stuff about entertainment litigation. Let's go over a couple of just the Temptations have been your client, Charles Bronson, Richard Pryor. Can you tell us a little bit about that?
Yeah, those were fun. So the estate of Charles Bronson, that was the movie royalties case. One of them we sued out over how the estate should have been paid for home video royalties. The Temptations, that was great. I mean, that was really fun. When we went, the clients, I'm sure they ask you the same way, their depositions were being taken, how should we dress? And we said, wear a suit, look nice. And so I came out of the elevator on the day that the Temptations were to be deposed, and they were wearing like suits that they would wear on stage in the 70s. And so they had their collars pop points to the side, they had pinstripes, they had their names embroidered on the legs of their suits. And they had one guy had like a pork pie hat on, and we're walking through this giant law firm in Century City, a defense firm, and everybody's quiet because everybody knows it's the Temptations. And then there's me walking behind them. I'm like, yeah, I'm not with the Temptations. And people are laughing and they know that. And I'm sitting there, and I said to one of the clients, I said, that is great. I'm going to have everybody at the firm get their name embroidered on their leg of their suit, because that would just be, to walk into court with a team of lawyers and you all have your name running down your leg. That's fantastic. So, but that was a digital downloads case. And that was, again, nobody at the time that the Temptations signed their contract were thinking, okay, so years from now, there's going to be a company called Apple that's going to allow you to download music. Is that a license or a sale? Right? And that's where we come in as lawyers, is to try to clarify. Everybody thinks when they're signing a contract now, they have it all figured out. Believe me, go forward decades, whether it's home video, whether it's digital downloads, whether it's whatever you can think of, some service industry, there are things that are happening that we just cannot even envision 20 years from now. And that's where the lawyers come in. But the entertainment cases are fun. There's no doubt about it. When you tell people you've represented the Temptations, they know you've represented somebody really great.
Is that a video deposition when they were dressed up?
It's funny. I don't think they were. I don't think there was a video for that one, which is a shame.
Yeah.
So, but sometimes it can be exciting. I mean, having worked in the entertainment world, and that's where I used to work, was in the entertainment industry as well for Dino De Laurentiis. There are a lot of people with big personalities. And when you represent a big personality, a director, let's say, who's used to giving direction, and you're telling him just to answer the question in the deposition, and then they would rather fight with the defense attorney over what he was saying doesn't make any sense, and you're saying, no, you have to listen to me, and like, no, I don't listen to anybody. Like, okay, great, this is going to go well. So, a lot of personalities in the world of entertainment.
Of course, yeah. Let me, I wanted to touch upon mass torts. I know we've been talking a lot about class action, and you've given us a lot of your time. I appreciate it. I won't take much more of your time, but let's talk about mass torts for just a minute here. I know that class action, you have class rep, you have common injury, remedy that has to apply to the whole class. You have a class rep who's aware of the issue, that remedy provided him will assist others. I appreciate all that stuff. What about mass torts? What's the nuts and bolts of a mass torts case?
So typically it's the injury that affects the person is going to differentiate a mass tort from a class case. So we do a lot of medical device litigation here. So a hip implant that is defective from our point of view, that breaks, right? The injury that it's going to cause may be applicable across everybody who had one break, but in terms of the damage and the injury that it caused, that's going to be specific to the person. So you can't certify that as a class case, because there's no easy way, unlike with a car, for example, that everybody's going to suffer the same injury. So a lot of medical device litigation are mass torts So you have a whole lot of people who are filing claims. They can't bring them together for purpose of a class case, but they can bring them together to say, okay, everybody, let's just stop. Let's do some discovery that's going to apply to everybody. Then let's put up what are called bellwethers, and let's start having some trials of certain cases, because that'll give everybody an idea about what the value of this is worth, right? And sometimes it's plaintiff, you pick some, defense, you pick some, sometimes, then it's alternate, sometimes the judge will pick, and you go through the bellwether process. And we're actually doing that right now on all of the roundup litigation. And I was in court all day yesterday on Sargon hearings relating to the roundup trial. It's going to take place downtown LA. And that's a bellwether case. And at the same time, there's a roundup trial that we're involved in out in San Bernardino that's going on right now. So if somebody gets a call and they think to themselves, this sounds like a really good case, however, right? And the however is everybody seems to be injured differently. The Jewel pods, right? There are a lot of personal injury cases that were filed, and I think we have around 700 on file, and I think we have that amount more that are going to be filed. Those are all have been brought together in the state's version of an MDL, a multi-district litigation, and they've been brought together in a JCCP here in LA, and they're all together kind of like a class case. However, you do this common discovery and then you kind of push them out, and then those cases get tried individually, and they're very expensive. So before, when we were talking about make sure you know what you're getting into with a class case, you certainly do not want to sue a gigantic company like Monsanto or a giant medical device manufacturer or a giant pharmaceutical company and write that check on an individual case. That is a very expensive way of practicing. So that's another distinction that you have to keep in mind with mass torts as opposed to class actions.
And the expense is incurred because it's a lot of this mass tort stuff is a theater of experts. Is that what causes the expense?
A lot of experts. You have, if it's a device, you're testing the device. These experts are very expensive because they've spent decades getting specialties in a certain area. And as I said, you're typically looking at document productions of millions of pages, which you then have to host, and that's a big fee alone. And so there's a lot of, just imagine a single case multiplied by 50,000, and all of those things that you would do with that single case, you now have to do over 50,000 cases, and it's just a very expensive practice.
I can imagine. So I was involved early in my career. I haven't done any mass tort, but I was involved early in my career in construction defect litigation, which these were not class action cases. They were multi-plaintiff cases. They were business torts and contractual issues. I remember when I did that work, it was interesting. It did often operate similar to a class action, except rather than having a class rep, you ended up having several class, they're not called class because there's no class, it wasn't a class action, but you had exemplars. We had clients who were examples of the issues going on in these tract homes. Mass torts that you do, it's not like that. Everyone is its own litigation. Is that correct?
Well, everybody's filed their own case. There's a case against an auto manufacturer that settled as a class case, and a bunch of lemon law attorneys who do great work. They decided that the class action was not for them, the settlement. They opted out, all of their guys. They filed individual claims. So now there's I think at the time there were maybe 1,500 of those cases filed throughout the country, probably more. And the defense said, wait a second, we're not going to litigate this in 1,500 separate courtrooms. Let's bring them in front of one court, right? And we'll have an MDL created, a multi-district litigation created. Same thing with hips. If there's a defective hip, it doesn't make any sense for scale to have 2,000 of those cases throughout the country where you have 2,000 judges and deciding many of the same issues that are being presented. Does this person get this piece of discovery? Do they not? Is this allowable? Is it not? So let's bring them all together, and you litigate. Those in leadership are litigating on behalf of everybody. And then at the end, bellwethers are chosen, and those are the cases that go to trial. And depending whether you're in state court or federal court, typically if you're in an MDL, you have a right to go back to where you originally filed it. So MDLs are created in front of the judicial panel on multi-district litigation, which is its own amazing place to argue. I argued there. These are people who are picked. I think the chief of the US Supreme Court picks the head of the JPML, and then the other people are picked as well. And I went there to argue a motion, and there you talk about a free-for-all. The clerk comes out and says, how much time do you need? I said, well, how much time have we been allotted? 2 minutes. That was oral argument, was 2 minutes. And then there were 5 defense people on the other side. One guy's like, I want 20 seconds. I want 10 seconds. Oh, what is going on here? This is crazy. So, but they bring all the cases in front of one judge who then oversees everything. Robin Hood was in the news. We were involved in the Robin Hood litigation. All those cases that were filed across the country, about 50 of them, eventually got sent to Florida. And they've now been put together in front of one judge who then wants to see one complaint on behalf of everybody and only wants to deal with one thing at a time. And then eventually there'll be discovery and things will happen, assuming that they get by the dispositive motions. And then at the very end, you'll have a choice in the MDL. Do you want to go back to where you originally filed the case, or do you want to waive what's called lexicon and stay in the MDL and try your case there? So the VW clean diesel cases, it was the same thing, all in the Northern District of California. And if you wanted to, you had a right to go back from where you originally filed the case.
You are clearly involved in a lot of, let me guess, Porter Ranch. I'm pretty sure Kiesel Law is involved in that as well.
Yeah.
You are involved in a lot. You mentioned the Jewel case, the Jewel pods, or whatever they were called.
Yeah.
You're clearly involved in a lot of this stuff. Is it a situation where a lot of firms come together for these types of things? I think Porter Ranch, I have no idea how many firms are involved, but as I understand, you guys are in the leadership role on that one. Is that correct?
Correct. We typically get into either what's called the liaison role or the lead role. So the auto litigation that was in the Central District, we were the lead liaison for the MDL. And then there were 2 JCCPs created, one up north and one down here. And we were lead liaison in both. When you're in liaison, you're kind of like the go-between. So people are doing the nuts and bolts of the litigating, which you're involved as well, and you're overseeing that, but you're kind of the interface with the court and the other side, and the other side has somebody in a similar position. So we like to sit on top of the litigation, but there's a lot of people who, like all those advertisements that you see on TV late at night, if you're ever up late enough and you see people advertising about whatever it is, typically those are not the people who are going to be leading the litigation. What they're doing is they're warehousing the litigation so that they could either refer over, or if there's a settlement, then that way they can get their clients into the settlement.
That's interesting. So the judge chooses who the liaison is, or does the group of attorneys and the plaintiff side choose?
Depends on your judge. And it depends on whether the plaintiffs can self-organize. If you can get people together and agree on a leadership, then you can just tell that slate to the court. If people are fighting, then there's a mechanism by which you present your bona fides to the court, and then it's up to the judge to decide who is going to lead the litigation.
Okay, interesting. That I was not aware of. Let's do this. Let's talk about, I also know, look, I to be honest with you, I think you and I could sit and talk for like 3 hours.
Yep.
I would actually like to have you come on the podcast, just talk about your cases, because your cases are all the ones we hear about in the news. So there is a lot of information there I want to get out of you. I don't know if we have the time for it today. We're already over an hour, but I did want to close up with financial services litigation. When I first saw that on your website, I was like, well, I mean, how exciting could this be? But then you and I were chatting about it before the podcast. Could you tell me a little bit about what you do in that area?
Sure. So financial services litigation is you have somebody that lost money, typically through an investment, and the investment was not proper. And in those instances, you can actually go against the registered investment advisor or the person who said, put your money in this. Just because you lose money, of course, doesn't mean that you now have a claim, but your situation, it's dependent on your situation, on the advice you should be getting. So we had a case of a person whose parent started a company that was making this product, let's just call it a widget. The widget becomes fabulously needed in factories throughout, I think, the country or the world. Company gets bought out. This person, the daughter, gets tens of millions of dollars because of her small ownership of her father's company. She goes to her investment advisor and says, hey, I just got $50+ million. I think I'm gonna have to pay taxes on this, right? And the answer is yes. What should I do? Let's put some of it aside to pay taxes, right? That's what the investment advisor said. So far, so good. Everybody would agree with that. The problem was he then takes that money that this person needs to pay taxes in less than a year and invests them in a very complicated managed futures feeder fund, a scheme. and she loses, I think it was $3 or $4 million in a matter of a couple of days. Now, if I went up to the average person on the street and I said, hey, I got to pay taxes 6, 8 months from now, and I have the money right here, what should I do with it? You might hear stick it under your mattress, stick it in a CD, put it in a savings account and get 0.000% on your money. But nobody would say, I have a great idea. Let's put this into some crazy options deal and we'll see if the volatility index goes the right way. And you would look at them and say, what are you talking about? So she went to this professional. The professional recognized that she needed to do something in the future, and then unfortunately recommended the wrong vehicle for her to put her money in, loses the money. And then the question becomes, what's to be done? And the answer is, unfortunately for the investment advisor, to go after him, because that was the wrong investment for her time horizon, right? If she had come and said, I have $10 million, I'm willing to put it in whatever you want. I'm willing to speculate. My risk tolerance is off the charts. Do whatever you want. Okay. But if the person is saying I need to pay taxes, that money has to be there. And so that, in kind of a nutshell, is what the financial services cases are all about. Typically, it is somebody being put into, that's called a typicality thing. Somebody's being put into an investment or a vehicle that just doesn't make any sense. Somebody who is 25 years old, who has investments that they want to make for the rest of their life, who has a pot of money, is in a different place than somebody who's 80, who needs it every day in order to pay their bills. And so that's one thing. Another thing is sometimes you're being sold a product and you're saying it's very, very safe. Don't worry, there's no risk whatsoever. And in fact, there's plenty of risk. So once again, there's liability there. And typically those claims are filed into arbitration. You have to either go into an organization called FINRA or the NFA, the National Futures Association. And so depending on the vehicle and depending on who the advisor is with, that's where you're going to go. It is a streamlined process. It's a bit of the Wild West in terms of the rules of evidence and the application of law, but that's just another area. And of course, you could always, if you can figure it out, perhaps make it into a class action. But then those are complicated by the federal securities acts and things like that. And that's just a whole other layer of excitement.
The financial services litigation is usually individual plaintiffs.
Correct.
And it sounds like there's both a sort of a subjective objective standard, which is it sounds like the timetables, age, maybe even sophistication of the plaintiff is taken into consideration when it comes to.
Yeah, I mean, if that's that kind of a case, if it's simply that the investment was, this is super safe, and in fact, what they were doing was, buying Ethereum and Bitcoin and Dogecoin and putting into cryptocurrency, then, by the way, I'm a big fan of cryptocurrency. So Bitcoin and Ethereum are not in the same category as Dogecoin, but that's what most people say. What do you know about Dogecoin? I'm like, oh my God. So it's not always, was this appropriate for the person, but sometimes it's just like any other product. It's being represented as something which it's not. And when the which it's not happens, then the question becomes, who do we now look for recovery to try to get some of that money back? And my friend would say, nobody, buyer beware, but that's not what we do for a living. It's up to us to figure out how to try to turn that lemon into lemonade if we can.
Awesome. That does actually sound quite interesting, because how many, forget lawyers, how many lay people wonder about financial and investment advice they get, and how many lay people get questionable financial and investment advice, and where is the threshold between, it's not that you just lost your money, like you said, there have to be other factors, I assume, and where that threshold is does sound quite litigious. It sounds like two lawyers might have that argument. Am I getting the feel for this area of the law?
You are, and you also hit upon something that I'm not sure if you realize, which is a lot of times the person has suffered a loss and they're so personally embarrassed by it, right? It's like that person that wires money to the Nigerian prince. How did I not know that was, because you didn't know, right? That's it. And so when you go to an investment advisor, you're looking for them and you are expecting them to act with your best interest in mind. It never would occur to you that I'm giving money to somebody who's going to purposely cheat me or purposely churn my account, right? To make so many different trades that they're making money for themselves and not for me. Nobody knowingly would do that. And then when the loss happens, the natural inclination is not to pick up the phone and start telling people, hey, I just lost all this money, right? No, so it's kind of a very interesting area because it's not like med mal or a PI case where something has happened and the natural inclination is something bad happened, I should do something about it. And it's kind of more of an introspective thing at first, because the person's like, how could I have been so stupid that when I knew I had to pay taxes and I gave my $10 million to my investment advisor, why didn't I think that that was a dumb idea, right? It's not up to the person to figure that out. So that's the twist to it. But you're right, there is a lot of fighting. Was this appropriate? Was this not appropriate? And then some of these investment vehicles, I've sat in these depositions. It's difficult to follow along when they start talking about volatility indexes and managed futures and this, that, and the other thing, and quants and all this stuff. It's exciting.
Yeah, I can imagine. I can also imagine it being quite complex. I don't know much about the financial sector, so when you start saying quants, I don't even know what that is.
No, but think about it. You like cigars, right? So if somebody said to me, somebody said to you, can you explain to me the wrapper versus the stuff inside the cigar? Is that just like ground up wrapper? Is that what's in there, right? And if you tried to explain to somebody that the beginning, how a cigar tastes isn't necessarily how the end third is, right? Or how the size affects it, or the air, all that stuff that you take for granted just because you know that you kind of get immersed in this. And that's what's cool about what we do for a living on the plaintiff side. We're not doing the same thing every day. You become an expert in this specific piece of a car. In the roundup litigation, you get an expert in cancer and how these chemical agents interact. In the hip litigation, you learn about metallurgical things, right? I mean, so that's the fun part about what we do, is you get to be an expert in different areas throughout.
Yeah, I had a case. It was a third-degree chemical burn caused by a cosmetic hair procedure where the client was changing her hair color. I know a lot more now about bleach and going platinum blonde and box dye and all this stuff that I would have ever imagined. I've never changed my hair color, but I know quite about it now. So yeah, it is kind of interesting. We become these like mini bundles of knowledge on random areas of the law. I really like it. I think we both seem enthusiastic about it. There's an intellectual curiosity which I think is quenched through that process.
Completely, 100% agree with you.
Yeah.
So tell me, what is the difference between the type of tobacco used in the wrapper then versus the fill?
The wrapper is actually more of a cosmetic thing. The vast majority of the cigar flavor comes from the inner, it's not the outside, but they save good looking tobacco to wrap around the outside because looks matter. When you go to pick up a cigar, if it's all blemished and stuff, you go, oh, that looks gross. But the tobacco on the inside has a million blemishes. You just don't see it because they wrap it with a nice wrapper on the outside. Of course, it affects the flavor, but the majority of the flavor is coming from what's inside the cigar, which you can imagine 99% of the tobacco is inside the cigar. Did I answer the question?
You did very well. Thank you.
But I appreciate it. Wonderful. Look, Jeffrey, the truth is you and me probably should sit for a cigar because we could do this for hours and hours and hours. Why don't we do this? We should talk about having you come back. I want to get, we got into messaging and class action and big picture stuff and defense bars messaging versus the plaintiff bar and tort reform in the McDonald's case. Let's talk about your actual class actions and mass tort cases and maybe get into the nitty gritty. Let's do that in another podcast. I think for today, we're almost at an hour and a half. So I appreciate your time. I like to leave a segment at the very end to let the guests say anything they have to the audience. If you want to help people reach you or whatever it may be, or if you just have something to say, sir, please, by all means.
Now, I would first of all, thank you for having me. And maybe what you should do is, like, rather than comedians in cars with coffee that Seinfeld does, you could have attorneys with cigars talking about something. I think for the new folks who are getting into it, look, it's not an easy way of life. You're not delivering letters where you have a box of mail and at the end of the day, your box is empty. As a litigator, we have lots of cases that we really want to focus on, and you have to be used to a lot of what I call balls in the air up there. And if you feel comfortable with the stuff up there, then this is probably not the thing for you. But assuming that you do want to litigate, as a young person getting into it, I would really think of, again, this sounds weird, but meditation, stoicism, and jujitsu. I think those are three things that if I had gotten into early, it really would have helped. And those will help keep you balanced, and it'll help you also be a better litigator. So that's it. I don't need any self-promotion, but those are the three pillars I think that would help a lot of people seeing this.
I think I need to buy Hickson's book is what you're telling me. To be honest with you, I probably will.
It's a great book. You should get it.
I believe it. What did I see him on? Was it Tim Ferriss maybe or some podcast?
He was on Jocko for
Jocko,
3 or 4 hours. Yeah.
Oh, yeah. Talking about breathing and how breathing affects, perspective and how the maintenance of, and by the way, he's not the first person. I've seen people from this organization called TACFit, which is short for Tactical Fitness. They're also talking, first time I went in there to exercise, they criticized my breathing first and foremost. So
interesting.
Yes, that was they're like, you're breathing too fast and you're breathing too shallow. You got to fix.
Did you read the book Breathe? Because I haven't read it yet.
No, I have not. This is just what the TACFit guys were telling me.
Okay, so there's another book. I'll send you 2 books. I'll send you the Hickson book and I'll send you the Breathe book. But those are both about that. I mean, look, Wim Hof, the reason why his method is so big right now with breathing is because obviously we're probably not doing it correctly, which is kind of hard to understand, but I do think there's something there.
Is he the guy, Wim Hof is the guy who takes a dives and holds his breath for someone?
He's the guy in ice and the one that ran up Everest in like his bathing suit, and he's called the Iceman. He's been put in ice, but a lot of what he does is based on breathing and just simply controlling the body through breath. And it's been scientifically, I've actually looked up the papers. It's been scientifically proven. So it's really pretty amazing. So there's a lot of interesting work there.
Does he take oxygen when he does Everest?
I don't know. I think he did it without oxygen. I think that was an unassisted ascent. But the fact was he was also not wearing, I'm pretty certain it was Everest, and he was not wearing any shoes. It was something insane. I'm not suggesting anybody should do it, right? There should be a disclaimer now. But going back to breathing, again, somebody has side control and they're putting all their weight on top of you, and you have to be able to be comfortable in that position. Just like when you're in court. You're going to get butterflies. You're going to be excited when the judge asks you a question. You might freak out or outwardly want to freak out, but inwardly are freaking out. You have to learn how to calm down and be comfortable in that situation. So again, the breath, the whole thing is there for you. And scotch and cigars, of course. That's important.
A little bit of that. Well, Jeffrey, we definitely have to have you back, sir. You are a just wealth of interesting information, experience. You work at a great law firm. You're doing wonderful things. You're doing big cases. It's really a privilege for a guy like me to be able to reach out and have these conversations with you, sir. So thank you so much for taking the time. Let's get you back on sometime soon, okay?
I appreciate it. Thank you for doing this. Really appreciate it.